In today's video, we're going to talk about shareholder disputes under Florida law and what they mean for your business. By the end of this video, you'll learn what constitutes a shareholder dispute, the most common types of conflicts between shareholders, your legal rights and remedies under Florida statutes, and the steps you can take to resolve or prevent these disputes from destroying your company. I'm Santiago Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I see this exact scenario play out constantly, especially in closely held and family-owned companies. When business partners stop seeing eye to eye, it can feel like the world is ending, but it doesn't have to. You and your business partner built this company from scratch. It started with a brilliant idea, a handshake, and more late nights than you can count. Now it's a success. The money's finally rolling in, but there's a huge problem. You two can't agree on anything. He wants to take on massive debt to expand, but you want to be more conservative. He wants to hire his unqualified cousin for a key role. You want to find the best person for the job. Every talk is a fight, every decision a battle. And the company you both bled for, it's completely paralyzed. Suddenly, you're not just worried about the next quarter. You're worried about the whole company could just implode. The business bank accounts could get frozen. Key projects are dead in the water. You are completely gridlocked, and the dream you worked so hard to build is turning to a waking nightmare. This is an incredibly common and dangerous situation called a shareholder dispute, and it's one of the fastest ways a great business can fail. So what exactly is a shareholder dispute? Think of it as a business divorce. It's a conflict between the owners, the shareholders, that gets so bad it paralyzes the company's ability to function. These fights are most common in private, closely held companies where the owners are also the people running the day-to-day operations. And just like in a marriage, a small disagreement can escalate until it threatens to tear the whole thing down. The primary statutory rulebook for these conflicts in Florida is the Florida Business Corporations Act. This is found in Chapter 607 of the Florida statutes. This law sets the rules of the road of how corporations have to operate and what rights shareholders have. When those rules get broken, or when the owners are hopelessly deadlocked, you've got a shareholder dispute on your hands. To see how these disputes really happen, let's go back to our story. We'll call the partners Alex and Ben. Alex owns 60% of the company, and Ben owns 40%. In the beginning, the ownership split didn't really matter because they agreed on everything. Now it's the root of all their problems. Their situation is a textbook example of what triggers these disputes. First, disagreements over major decisions. This is where it usually starts. Alex, the majority shareholder, wants to take out a huge loan to open up 3 new locations. Ben, the minority shareholder, thinks it's way too risky and wants to upgrade their existing equipment first. Because they're at an impasse, nothing happens. The business just stagnates, caught in the crossfire. This is a classic deadlock. Second, breach of fiduciary duty. This is a legal term, but the idea is simple. The people in charge have a legal duty to act in the best interest of the company, not just themselves. Let's say Alex, fed up with the deadlock, decides to flex his majority power. He jacks up his own salary to a ridiculous level, calling it an executive bonus. He then tells Ben the company can't afford to pay dividends because profits need to be reinvested. In reality, Alex is just siphoning money from the business for his own gain, starving the company, and crushing Ben's financial interest. That's a form of self-dealing and a clear breach of his fiduciary duty. Third, there's a shareholder oppression. This is where the power imbalance gets nasty. Shareholder oppression is when the majority owner uses the control to squeeze out or unfairly harm the minority owner. Alex takes it a step further. He stops inviting Ben to important meetings. He denies Ben's request to see the company's financial records, even though Ben has a legal right to inspect them. Then Alex holds a vote, which he knows he'll win with his 60%, to issue a ton of new shares and sell them to his wife for cheap. This move, called share dilution, puts the value and ownership percentages of Ben's 40% stake, wiping out his power and the worth of his investment. Ben is now being systematically frozen out of the company he helped build. And fourth, valuation conflicts. The last straw comes when Ben decides he's out and wants out. Of course he does. He tells Alex he wants the company to buy back his 40% stake. Alex agrees but offers him a ridiculously low price. Alex knows Ben can't just sell his shares in the open market. It's a private company after all. He's trying to strong arm Ben into a cheap exit. This is a valuation dispute, and it's a huge battleground when partners try to separate. These four scenarios, deadlock, breach of duty, oppression, and valuation disputes, are the cornerstones of almost every shareholder war. So, what does Florida law say about Alex and Ben's mess? Well, the Florida Business Corporation Act provides a playbook for exactly these situations. But before we get back to Alex and Ben, if you're a business owner finding this valuable, do me a favor and hit that subscribe button. We put out videos like this to give you the insider knowledge you need to protect everything that you've worked so hard for. All right, back to Alex and Ben. When Alex paid himself that insane salary and hid the financials, he likely breached his duties of loyalty and care. That duty requires him to put the company's interests before his own. It's true that Florida courts have rejected creating a special heightened partner-like duty for closed corporation, but the standard of duty for loyalty and good faith absolutely still apply. Now, when confronted, Alex's lawyer might try to use something called the business judgment rule. This is a legal principle courts use that generally protect directors from getting sued over business decisions that turn out badly as long as the decision was made in good faith and with the company's best interest in mind. But that shield disappears if there's evidence of self-dealing, fraud, or a complete lack of a rational business purpose, which sounds a lot like what Alex was doing. Ben, our oppressed minority shareholder, isn't powerless. Florida doesn't have a specific law titled shareholder oppression. Courts use the tools within the Business Corporation Act to protect minority owners from these exact kinds of abuses. Ben's right to see company records, his right to fair treatment, and his right to sue are all protected under Florida law. If you feel like you're in Ben's shoes, it is critical to know you have rights. Under Florida Statute 607-1602, you have the right to inspect and copy corporate records, like financial statements and meeting minutes. This is your transparency tool. If a majority partner is hiding something, this is often the first legal step to bring it into the light. You also have the right to sue for wrongdoing. This can be done in two main ways. The first is a direct action. This is a lawsuit you file in your own name to protect your personal rights, like when you're denied dividends or your voting rights are ignored. The second one is called a derivative action. This is a lawsuit you filed on behalf of the company against a director or officer who has hurt the corporation. For example, if Alex's self-dealing damaged the company financially, Ben could file a derivative suit to get that money back for the company. These suits are complex and usually require you to first make a formal demand on the board to fix the problem. And of course, you have fundamental rights to vote on major company changes and get your fair share of dividends when they're paid out. When a dispute can't be settled by talking it out, Florida law gives courts several legal remedies, the tools they can use to fix the situation. First up is monetary damages. This is the most straightforward. If a court finds Alex's actions, like taking an improper salary, cost Ben or the company money, it can order Alex to pay up. Next is injunctive relief. An injunction is a court order that forces someone to stop doing something. Ben could ask a court for an injunction to stop Alex from selling those diluted shares to his wife or using company money as his personal piggy bank. There's also a forced buyout. In many oppression cases, a court can order the majority shareholder or the company to buy out the minority shareholder's shares at fair value. The court will often order an independent appraisal to see that value. So Alex's lowball offer would get tossed out. This provides a vital escape hatch for a trapped minority owner. Next is judicial dissolution. This is the nuclear option, the business death penalty. If a court finds that the owners are hopelessly deadlocked or that the people in control are acting illegally or fraudulently, it can order the company to be dissolved and its assets sold off. Now, it's a drastic step, but sometimes it's the only way to make sure a minority shareholder gets their fair share of what the company is actually worth. If you are in the middle of a shareholder dispute, it can feel like you're drowning. But here are 3 immediate practical steps you can take to protect yourself. The first one, review your shareholder agreement. Before you do anything else, find and read your shareholder agreement, operating agreement, and company bylaws. These documents are your company's constitution. They might already have rules for resolving disputes, like mandatory mediation or buy sell provisions that spell out exactly how a partner can be bought out. This agreement is the bedrock of your legal position. Next, document everything. Start a detailed log of every single disagreement, questionable transaction, and shady behavior. Save emails, texts, and meeting notes. If you ask to see financial documents, put it in writing. If you're shut out of a decision, write that down. This paper trail will be priceless if you end up in a legal battle. And third, seek legal counsel. Don't wait for the explosion. The moment you sense a serious conflict brewing, talk to a Florida business attorney. An experienced lawyer can help you understand your rights, tell if you have a strong case, and guide you on the best strategy, whether that's a tough negotiation, mediation, or a lawsuit. Getting advice early can often resolve a dispute before it destroys the company and racks up massive legal fees. Look, navigating a shareholder dispute is incredibly stressful, especially when it's with someone you once trusted completely. It's a messy mix of business, money, and raw personal emotion. But just understanding that you have rights and that there's a legal process for this is the first, most powerful step forward to protect your investment and your future. The law provides a path forward even when it feels like you're hit a dead end. Don't wait for the problem to solve itself. Take action now to protect what you've built. I'm Santiago Cueto, your Florida business attorney. Be sure to subscribe to my channel and watch more of my videos right here.